I haven't got this all confirmed with my group, but I'm sure they agree.
Okay, all right.
Made me chair for 7 years, so I could take some liberties.
John Groveman is scheduled to testify in S-45. And then after we take a break, we're gonna have more testimony on the bill we were downstairs hearing about yesterday. So at S-124. And that'll bring us up to lunch. I think we're gonna have another relatively short floor today. So tentatively planning to be back here 10 minutes after the floor to hear more testimony on S-45. So that's today. I think we can go ahead. Paul, I know you've been here before, so we've met before. Welcome back. And if you want to get started.
Well, thanks for the invitation and good morning. My name is Paul Doughton. Along with my wife and our son, we own and operate Doughton Farm LLC in Barnard, which is a little north of Woodstock. We are certified small farm operation. We have a total of around 100 Holsteins. As my 4-year-old granddaughter says, Daddy does not allow jerseys on our farm. We had jerseys on the farm until 1966, when my father decided it was time to move to Holsteins because the cats kept catching calves. And he didn't want to have that continue. So I don't think it actually happened that way. We are currently, my son is currently milking between 60 and 65. As a little background, my parents moved to the farm in late 1949 after my maternal grandfather sold the farm to someone outside the family. They were living at Billings Farm where the farmhouse is now. And then that family was unable to make the payments, so my parents took it over at that point. I was in a partnership with my parents beginning in 1979 after graduating from the University of Massachusetts in Amherst. For any of you who have basketball background, Dr. J is a day older than me, and he was a freshman there. That's the only claim to fame I have. I knew him then, I don't now. In 1992, I took over the farm with the passing of my father. Between then and 2005, we formed Doughton Farm LLC with our son to make an avenue to transfer the farm to him. He had graduated from high school in 2004 and had no desire to do any higher formal education. Now it's that little cell phone in his hand and he can find out any information he wants. I don't know why salesman comes, but I just tell him anything because he knows what the answers are before he asks the question, which is very enlightening to have somebody jump up like that. Over the year, there have been changes to the number and the knowledge of agriculture by our neighbors. And with that change in the number of animals and the need for forage for our cattle has increased over the years. In early 1950, my father was milking 12, 15 cows. As time moved along and there were 4, 5 children in our family, he moved up to milking 30 cows. With those 30 cows, he put all 5 of those through college. In the early 1960s, we started having a community picnic as a way of thanking our neighbors for tolerating the twice daily crossing of Lakota Road of our herd for grazing. It is about a 2-mile circle of farm that we invite our neighbors. There were 25 invitations when this started. This past fall, we invited 125 and 75 came. We are now spreading a little further for our forage than we did before. We go 6 miles north and south of the farm to get enough feed for our animals. We cover around 225 acres of hayland between 3 and 5 times each year. We do not grow corn for our cows because we do not have corn land. It's too many stones, not well drained. But instead we buy 300 ton of already chopped into a dump truck and delivered corn silage at harvest time. We do grow sweet corn, and there are usually questions about, is it GMO free? And do you spray with Roundup? The answer to both is no. It is not GMO free, and we do not spray Roundup, but we wish we could because the weeds are catching up with us. spreading of manure on these fields has not been a concern for most of the fields we use. We try to spread early in the week so the aroma of spreading manure doesn't interrupt activities. If these people come to their weekend $1.5 million home for, a young couple from Boston with 2 children, I guess they don't really like the smell of manure, but they understand that we need to spread it. We also make wrapped round bales and try to store them out of sight as much as possible as a way of making sure we don't get complaints. Only once can I think of a strong altercation with the owner of one of the new fields we took over from a farm that went out of business. We had spread manure on that field a couple times without asking permission and hadn't got any feedback. When our crop consultant got back to his vehicle with his gator after soil testing, he was met with a barrage of colorful language and a threat of arrest for trespassing on his property. He also demanded that the sample of his field be destroyed, and if there was any data that the test that would also have to be destroyed. He did call the police and later through email threatened to take us to court if we didn't respond in a certain number of days. He also demanded the 3 of us in the LLC and the crop consultant signed a statement that we'd not enter his property without written permission. That is not a problem, but we'll never enter his property again. I also required that he and his wife sign the agreement that we complied with his demand to make sure he didn't keep doing. We don't have time or money to be fighting lawsuits. We were and are following the RIPs and taking soil samples every 3 years. I thought we were going to be helping him qualify for current use, and I'm not sure what the outcome of that is, but that's not my business. We have purchased a 10-wheeler truck with a side slinger manure spreader mounted so we can move manure from the farmstead area to more distant fields to make use of manure, which we all know is not a hazardous waste, but an important piece of the ecosystem. In closing, if dairy and other types of agriculture, and dairy especially, because of its contribution to tourism, are going to be continued into the future, and I look at my son as my focus, there needs to be a strong right to farm law in this state. The bill that was passed by the Senate gives us that path forward, and I support that bill. Thank you. Like I said, Richard.
Thank you.
I'm not in charge. Thank you.
Representative Nelson, go ahead.
Thank you. You serve on a board or two, don't you, as well?
Yes, I do.
Yeah. And what boards do you serve on?
Well, the most important one is Cabot, the dairy co-op. I've been on that for almost 3 decades now. I can't find somebody to take my place, but it looks like I'm going to be able to in the near future. I've just stepped down from the Vermont Milk Commission. Walt Gladstone has taken that spot, and I'm on the New England Dairy Board, vice chairman. I'm in my own town. I just announced that I'm not going to be moderator for our town meeting. I've done that for between 25 and 30 years, and I thought it was well for somebody else to step up. I gave him a year's warning. I'm a justice of the peace. I had somebody tell me the other day that I did their ceremony 28 years ago. I didn't think I'd been a justice of the peace that long, but I do. And he's married to the same woman, so that was wrong. And there are probably others that I can't think of right now, but I do not spend as much time off the farm as I used to, but I look forward to spending less time off the farm because I have 2 grandchildren that live across the field. Going to be 7-year-old grandson. Next week he'll be 7, and then a 4-year-old granddaughter, and then a 3-year-old granddaughter in South Burlington. I did just the Connecticut River Watershed Farmers Alliance, along with 2 or 3 other people. We formed that 7 years ago, and we're getting some accolades and some attention now. So it's important to make sure farmers are able to broadcast the things that they're doing positively. We want to make sure agriculture gets a positive outlook and a positive look in the press.
Glad you mentioned that one because that's one we happen to have listed on the agenda for your affiliation. How many members do the Alliance have today?
There are 65 that we have right now, and there are more that are going to be coming on because we do rental program with 3 different no-till seeders, some other apparatus that can be rented out. We just came upon and got money to have an executive director. And that's been a godsend to me because I was supposed to do the administrative stuff and I'm not good at that. But we did, and he's doing a great job.
Do you operate on both, or do you have members on both sides of the river?
Yes, very much so. And we're trying to make sure we concentrate that there is a New Hampshire. I think New Hampshire has the same situation that we do in Vermont. When we formed this organization, there was a understanding that Lake Champlain was the only body of water in the world. And the Connecticut River was just, something on the other side of the state. It's got to the point where when I went to meetings, people would say, you don't need to introduce yourself, Paul. We already know you're coming here to make sure there is a Connecticut River and the eastern side of the state is recognized. New Hampshire, the western side of the state has the same situation. There's a little more understanding that is a need for the waterways to be, not that they're doing bad, and we can understand the red target that was on people on the western side of Vermont, but there's also a need to keep track of the eastern side of the state, and that's being done.
Representative Basil.
Yeah, thanks for sharing your story. I have a question, and I don't mean this in a disrespectful way. It's a little bit of a devil's advocate kind of question. So it sounds like your farm has been going for about 70 years. And you described the one situation where you had a conflict with a neighbor, and it sounds like it was resolved pretty quickly without the courts. But then you closed in saying it's really important we have a right to farm so we don't have to go to court. So I guess I'm wondering, do you think that the climate is changing in a way that people are more likely to be litigious and you're going to need those protections? Because it sounds like for 70 years, you've been okay and you've been able to get along with your neighbors. Why do you think we need stricter legislation when it has worked out so far?
The world is changing.
Can you say a little bit more about that?
The neighbors that we have now are completely turned over, some of them 2 times in my lifetime.
Mm-hmm.
And they're getting further away from agriculture and understanding. My son, some nights will mow until 10:30 at night, and that might upset some people. Or when we turn the milker pump on in the morning at 5 o'clock, that might upset some people, or whatever else activity that might be going on. And also there might be activity if an animal seems to get out, trot up and down so far they've stayed very close by, but that does happen. We do not graze our animals at night for that reason, because I don't like to get a call at midnight saying your cows are out. We also keep our heifers in, and as a sort of a safeguard to that, because we used to pasture our heifers 6 to 7 miles from the farm, and then somebody would come in and say, oh, we got your cows out of the road this morning. But I think that, and that man that threatened us is I think something that's coming to the world today. All he had to do was come out and say, would you please get off my property? But he didn't do that. So he didn't know who was farming the land. Within 10 minutes, we'd already had a call from the police. Evidently he knew something. And then he emailed me. So it must be he really, and with the world the way it's going now, I guess I've got to be careful how I say it, but there's more people are more aware that they can say, you got to do this or I'm going to sue you.
Mm-hmm.
And I don't have time to listen to that. And my son is the one who does a lot of there's another example that came out positively. We took over some land that was inorganic, was organic to begin with. I'm not sure it was certified, but the owner said that we were going to have it and she wanted it kept organic.
Mm-hmm.
And if there was any expenses that were added to that she would cover it.
Wow.
One of the fields had more rocks and ledges in it than my son wanted to run our equipment over. So they hired somebody with one of these rototillers that would grind up stones and everything at like $1,500 or $1,800 an acre. No problem. We needed potash. No problem.
Wow.
And she called the other day or emailed, are you sure you're getting enough value out of these fields? I was glad to add some more. So that's, the positive things that can happen. Is to counteract the other side.
Yeah, thank you.
Representative Lipsky, you have a question?
Thank you, I did. You know, it was very disturbing interaction. But you brought up the current use, that if you lease or utilize agricultural land that you don't own, it could be a neighbor or that qualifies them, if it remains in agricultural use, to be eligible under the current. We've taken a lot of testimony this session on that. Do you know if that particular farmer has someone else managing his fields, or if he is enrolled in the use value appraisal?
I'm not aware. I'd stay far away from that.
No, that,
I think that
I
one of
get
the problems with current use, agricultural land current use, there's not enough oversight. There's a lot of these fields that are not being properly used to be under current use, and the people are getting the tax advantage without properly having it overseen.
thank you very much. That gives us something to look at.
Representative O'Brien?
Oh, just some miscellaneous questions. So have you always shipped a Cabot?
Yes.
Yeah. So you must be one of the longest running.
Well, I was with Agrimark before the merger.
Okay.
So I was with Agrimark and United and the ones that started before that. So no, I was not with Cabot originally. So, but obviously we are now. And our milk goes to Middlebury to be made into Cabot cheese, right?
And Richard's mentioned that the Nelson Farm has about 500 neighbors. If you look at all their, how many do you think you have? If you look at, both lease fields and fields you own and
Probably 35.
wow.
And it's expanded in the last 5 years. I mean, Matt, 3 years ago, we took on a farm right now near Woodstock that went out of business, and that really increased the number. And that's one of those individuals that we took over.
Just on the Alliance Farm. If you are farms like Carlo Farm down Michelle's Way, part of it, the big, maybe not dairy farms on the Connecticut, or Tara Sad, who's from Walpole and on the Council of State Government, she said that there's a huge chicken farm sort of in the Walpole area.
We're working on
Even Jerry's, I guess, up in Monroe, so.
we're working on that. If anybody knows Bill Emmons, but the beef guy in Pomfret who has on property restaurant, and he's my vice chair, and he likes to go for as many people as he can. As a matter of fact, yesterday in Westminster Farm, there was a trial or a field day that we talked about planting of triticale as opposed to winter rye, so they can harvest that and feed it as a real great feed.
Winter rye just gets plowed under or killed off, or
Yes.
so this would be a better possibly.
The field has to be stone free. That doesn't help in
Can-
the field. Coming into a chopper.
Can you explain a little bit for those of us who don't have the experience or the expertise? You were saying that the land, you're not planting corn because the soil is too rocky.
And there's not enough drainage.
Are those two things connected? The fact that it's rocky?
Yes. The fields where we get the corn from are down on the Connecticut River, and they get 30 to 35 tons to the acre. If we get 10 or 12 tons to the acre with our piddly little areas that we go. The last time we raised corn, we had 17 acres on 5 fields. The furthest one was 7 miles from the farm. It is no fun to haul a forage wagon behind a pickup that far. And it took us 2.5 weeks to chop the corn. As much time as I was off the farm, we decided it's time to hire somebody and just have it delivered. In a day and a half, we get 300 tons.
So that's I imagine true of your, not your immediate neighbors necessarily, not your 35 immediate neighbors, but in general, other land in the part of the state that you're in would not be as hospitable to growing corn.
That is correct. Yes. I make jokes with those guys along the Connecticut River. They've got to drive fast because the corn comes up before their planter runs over to pack it down. I mean, the soil is so rich.
Representative Nelson.
Little bit off topic. Tell me about the triticale. I was here. I couldn't go. Was it?
I did not go either. My son won't let me retire. I'm not sure how tall it was, but it was down in Westminster, right along the river. So I'm sure it must be up. And that, with the triticale, you've got to cut it the correct day. If it's a day early, it's not very good. If it's 2 days late, it's headed out and the value is gone.
Is that the Basin Farm?
Excuse me,
The Basin Farm in Westminster? That's where the dairy farm,
the Westminster Farm.
right on Route 5.
Yeah, yes. It's just by the underpass that goes across to New Hampshire.
Yeah.
They'll do that big 150-acre field and they grow half winter rye and half triticale because they can't chop them so much.
And this triticale isn't, what did you say that you had a great word for the winter rye? It's
Allelopathic.
Yeah.
Yeah, it's allelopathic. So if you don't get your winter rye under control, it can affect your next Mustang. Because it wants to kill anything growing with it that's not winter rye. And it, you can harvest it. It's a so-so feed, but this triticale is absolutely, I like to try it up home, but we're so far north. I don't see how we can get it mature enough to cut and replant it.
I don't want to get into the mud or the details, but there are some farms that do not want, you got to plant shorter season corn. You get it harvested by maybe Labor Day and then get the crop in so it can get a chance. There are, it's out when it first starts growing. But if you wait till spring for it to grow, it doesn't branch out, and so it's a science almost.
Yeah, it really is.
And there's a lot of difference between Dunkley's and Brattleboro and you guys up there. There's a whole different world. That's why we need flexibility with our spreading and everything that goes on in the state.
Any other questions for Paul? Representative Supernaut, I just want to make sure that since we don't see you, that you don't have a question.
I do not, just listening. And good morning, Paul. I'm sorry to miss you. It is my first planting day in Barnard.
The snow was gone last week, so you're ready now?
I'm ready now. Nice to see you.
Good to see you. I can't, but good to hear you.
All right. Anything else you wanted to add, Paul, before?
Excellent. Thank
Thanks for joining us. Welcome to stay, of course, if you'd like. And okay,
I
figured.
just want to get fired, or I'm trying to get fired, but he won't. Thank you for your time.
Thank you. Hey, Paul, thank you for all you do for the dairy industry. You're having an impact. It is.
All right. John, we'll move right into your testimony if you're ready and want to join us.
That New England Dairy you mentioned, that's the New England Dairy Promotion Council.
Oh,
And he's been on that board for a long time, back when my dad was on that board.
but a dues paying organization?
No, well, that's where our 10 cents per hundredweight goes, that they take out of our check automatic.
Oh, the check off.
Yeah, the check off, and it goes to the Vermont Dairy Promotion Council, and then they give 90% of it going to New England Dairy. Yeah. Yeah.
All right. Welcome, John. I know we had you scheduled last week and that we ran out of time.
Yeah, that's fine. I've developed a cold in that period of time, so hopefully you can hear me and
Developed
I don't think I'm contagious anymore.
in the.
Yeah, I spent the weekend in bed, so it's now makes me sound like this, but I feel a lot better. So
Do you want to show us anything on the screen?
I do not want to show you anything.
Okay. We're scheduled to be hearing from you for the next 45 minutes. So if you have less than 45 minutes worth of content, we'll fill the rest of the time likely with questions.
Yeah, no, I don't think I have quite 45 minutes, but I appreciate the time. And so, thank you very much. I appreciate that. So just to introduce myself, because I don't get to this committee that often, although I think I'll have this later. It's hard to talk and stuck at the same time. Yeah, I suck, so. So just a little about who I am in VNRC. I don't know. I know some of you know. I'm Representative Lipsky that I know in VNRC, and others. So my name is John Groveman, for the record. I'm the Policy and Water Program Director at Vermont Natural Resources Council. Vermont Natural Resources Council is Vermont's oldest, longest standing in-state environmental group. We were formed in over 60 years ago by farmers and foresters, basically in response to the changes that were happening to Vermont's landscape, with the interstate being built and demographics changing and land being developed. And for the same reasons that led us to Act 250 and the concerns at that time, there were people, and it was called the council because there was people, leaders, and especially in the agricultural, the working lands community, that were concerned about those changes and didn't feel that there was a voice in the legislature and on policy. And that's where we were born out of. Now we have 4 programs. We have a water program, which I lead, a forest health program, a climate energy program, something called Sustainable Communities, that deals with issues about zoning and livable communities. And then I'm the policy director, so I work with all the programs to help develop policies and advocate for them, but I'm also an attorney, which leads me to why I'm here today. Obviously, there are water issues involved with this bill, which I'll talk about, but obviously this is a legal bill. It's changing Title 12, which is our judicial statutes. And so I could speak, I'm going to speak to the bill from my expertise as a lawyer, but also as someone who works on the water quality issues. From the legal perspective, I've seen these issues around about lawsuits around farms or pollution generally from a lot of different angles. I was the A&R General Counsel for several years during the Shumlin administration. I was General Counsel at VNRC in another stint before I was the Policy Director. I teach a class at Norwich University. I've been teaching it for 10 years now on environmental law. It's an undergrad class, but we cover the whole range of our federal environmental laws, but also common law. So I teach, part of the class is about trespass and nuisance and negligence and the sort of common law claims. Common law, just to clarify, you've heard this from other witnesses, it's just basically case law, it's judge-made law. And so nuisance and trespass and negligence are laws that came from England, that when we became a nation, we adopted the case law that was developed in England over centuries, and it's become part of our jurisprudence. And it was really the first environmental laws that we had. So that's kind of my angle on this topic, just to give you that background. So as you've heard already, right to farm law. So every state has a right to farm law. And they were really born out of the idea that we have these, in particular, these nuisance laws that came from England, from common law, that, like I said, before we had any environmental statutes, federal, state, local, there was this notion that if there are disputes between neighbors and one neighbor is using their property in a way that interferes with the use and enjoyment of another neighbor's property, as a last resort, you could go to the courts to resolve those disputes. And right to farm laws kind of came out of that nuisance concept, understanding that farm activities could be perceived as nuisances and lead to lawsuits when farmers they were using their property appropriately. It's just that the people who often, and you heard this last week, kind of moved to the area where the farm was and wasn't used to that activity. The obvious examples which you heard and obviously thought about in looking at this bill are odors and dust, and these are things that I heard discussed last week. And the idea was that we don't want farmers to face litigation. We want to discourage litigation when farmers are just basically farming, and it's just people aren't used to those activities. And so VNRC supports our existing right to farm law, and we support that approach to deal with these issues. And the right to farm laws strike that balance, even with I think the appropriate goal of discouraging lawsuits that misunderstand when farming is happening in a way that is normal and in conformance with practices. You still balance, it's a delicate balance of the rights of the farmers to farm and do their thing versus other property owners. And we want to leave the door open for when there are situations where there are activities that aren't consistent with practices or an outlier and really causing harm to another property owner. We want to make sure that in those instances, people have a fair chance, if it comes to a lawsuit, to be able to go to court and address those issues. Been very few lawsuits, as you heard, in Vermont, and I think that's because of Vermont, and I've been practicing law in Vermont since 1995. It's just not a litigious place. You know, my friends who are lawyers in the other parts of the country, they can make a good living as a personal injury lawyer. Much harder in Vermont, and I'm proud to say that, because the first thing Vermonters don't do is sue each other. It's just not how it works in the state, and I think you all know that, right? Because we all live here. But we heard the concerns that have been raised about how the existing right to farm law works and some of the aspects of it that seem unfair in terms of the presumption being placed upon the farmer to prove that they're engaging in good practices. So, you know, if it's a nuisance activity, they would be somewhat insulated, or there'd be a higher threshold to leap if you wanted to sue in that instance. And we are in agreement with that. You know, I've heard enough. I have not been involved with the right to farm nuisance lawsuit, but I've heard the testimony, and over not just this year, but this issue's been bouncing around for a couple of years. And so we agree with the changes to rework how the presumption works, to make it clear that what does it mean to be in good standing and be in compliance with farm practices, so that you get that extra protection. It makes it harder to win those lawsuits. What we're concerned about, and I'll get into this very specifically in a second, is adding trespass to our nuisance law, which I want to be incredibly clear would make us a complete outlier in the country. There are 2 states, you've heard this, that include trespass in their right to farm law. We would be the 3rd. An outlier, none of the states around us, not New York, not Maine, not New Hampshire, not Massachusetts, none of them include trespass. And the reason is, and I'll get into the concerns about trespass in a second, is because of how these laws were born, as I described. They were born out of the nuisance idea, right? They were really born out of, I think, the common sense idea, which VNRC supports, that, yeah, farming, you know, it could be dusty and noisy and smelly and all those things. And people shouldn't mistake that for something interfering with their ability to enjoy their property if the farming is occurring in a way that is consistent with practices. But trespass brings us into a whole other realm. Legally, it brings in squarely water running off property, which is originally what got my attention to this bill. Having said that, I work on water issues. And it raises all kind of legal complications in terms of takings, which I know you're going to hear later from Professor Echevarria. He has research issues, an expert in takings, and he will testify, as you'll hear confidently, that if we add trespass to the bill, we're basically inviting lawsuits against the state of Vermont if a property owner feels harmed by an activity on a farm that is physically invading. That's the big difference between trespass and nuisance. The nuisance legal standard are you interfering with the use and enjoyment of property? Trespass is an actual physical invasion of the property. Nuisance odors wafting over dust, those are nuisance issues that has not been, the common law has not said that's a trespass. We're really talking about like drainage ditches going from one property to another on a consistent basis, not like in a one-time flood event storm, or, now I don't know how many major flood events we get every summer anymore, but it's really about the sort of consistent invasion of property. And I'll let Professor Echevarria address this more in full, but the suggestion that you could deal with the takings issue by saying in the law, Well, if it causes a takings, then that's not allowed. And so, we won't allow a provision that makes it more difficult to win one of these lawsuits if there's a trespass onto a farm property, if the court believes that it could be considered a taking, which under the US Constitution means the government would have to compensate the property owner for the lack of use of the property. That's just inviting litigation on that issue. That's all that's doing. It's basically saying to the court, every time there's a trespass claim, you need to decide whether there's a taking or not. I mean, that's what I would argue if I was a lawyer. If I was a lawyer for somebody who owned property and there was water running off of a farm onto my client's property and was causing damage of some sort and couldn't resolve it, and I went to court and brought a trespass claim. And then the farmer said, well, we have this right to farm law that says that you have this additional burdens now to prove this claim. And then I would raise the takings issue and say, look, Your Honor, it says right in the bill that if it's a takings and you can't put that additional burden on that lawsuit. And the judge is going to have to look at these takings issues in every single case. And I don't think that's good for the farmer. I don't think it's good for the neighboring property owner. And it's going to lead to confusion and not to clarifications in the law, which is what VNRC is willing to agree to. So, when I get to the end, I'd like to go through some changes to the bill, the last version of the bill that I have that came from House Judiciary to you, and go through it and point out where I think that bill even creates confusion and litigation. And my caution to all of you is to be really careful. Like, I really don't, I'm really been a little baffled by some of the testimony that, well, let's, add trespass to the bill. And as I said, but it can't result in a taking, because that's going to result in litigation on those issues and confusion. And let's define nuisance, which is a common law definition. And I'm not aware of other states that define nuisance. Maybe there are, but you don't need to do it. Once you define nuisance and then exceptions to nuisance, that's going to be litigated. What does that mean? What is the new definition of nuisance that's going to overlay the common law, and then there are exceptions to that. That's all going to result in confusion and argument and litigation. And I don't think that's what we want to do here. But I saw that you raised your hand.
Right.
John, right now, let's a couple of examples. Say Richard's heifers get out and eat my pole beans, or my German Shepherd goes and kills Jed's 50 chickens. Are those trespasses?
I mean, they could be. We have never had a case in Vermont where that's gone to court where any of those things have happened. I'm sure that there are cases where dogs have destroyed livestock where people get compensated and work it out, or maybe they go to court over that. And I think that's you're fairly obvious you're going to lose that case. So you're going to end up wanting to just make someone whole,
That's what's interesting is those kind of things happen all the time, and yet we don't.
There's no case. No, there's no case around that. And so I don't think you should add trespass into the law just to deal with an issue that's never really been a problem. And I think, so I live in Marshfield. It's a pretty rural town, and I see cows out. Like, there's like one farm in particular that's on the Marshfield Groton line, and the cows are out. And what happens is they don't do damage. People call and say, hey, get your cows off of my property, get your cows out of the road, and they come and get them. If the cows did cause damage, then I think the farmer or anybody would say, well, we need to, but are they damaged? And we'll pay for it. I mean, the trespass cases, the case law, and not even in the farming context, although I think it relates, is like when we talk about toxic pollution, the original toxic pollution legal protections were trespass. So if you release toxic chemicals, like take the Bennington case with PFAS, the one that started all of the PFAS lawsuit. Those lawsuits that were filed by the property owners against Saint-Gobain were based on nuisance and trespass. It was a release of chemicals onto someone else's property. it's not, things like property damage from cows or dogs or things like that. And if that's a concern, like, I think there would be a better way to do it than to change the right to farm law and then to add in trespass and create all these legal complications.
Representative Nelson.
Thank you, Chair. When cows get loose and go on someone's lawn, you fix the lawn, fix a few. And you fix it better than it was before. That takes care of all those problems. On the issue of trespass, you mentioned water. And of course, water runs downhill. And I think that we can all agree that when it rains, water leaves one property and enters another. And we have the RAPs that we have to follow as farmers. So we're not polluting. And in the state of Vermont, the bar is higher than essentially any other state, unless it's a big rain event. So we have protections there with our RAPs. But you talked about, water leaving the farm and going on someone else's property and affecting their property. Are you referring to that if I have a field and I ditch it and whatnot, and then I create a point conveyance that runs onto someone else's property? Is that what you're referring to?
That's an example, yeah. That would be one
Okay,
example.
and I think that is illegal to do. As I'm not allowed to do things on my property that will affect somebody else's.
So under the law, so nuisance and trespass, nuisance is interference with the right to use and enjoy your property. Trespass is a physical invasion. Importantly, for both of those, that causes harm. That causes harm. So it's not just the act of water being conveyed. It has to be harm. And the harm that I've seen that and it's very extreme. I want to say these suits are hard to win in any context. The toxic suits I mentioned, really hard to win because you have to show harm. And so the harm could be like erosion, I suppose. And, that could be a harm. That's pretty easy to fix, right? Like, okay, I'll redirect the water so I'm not creating erosion on your property. And the harm there is probably fairly mild and not very expensive to fix. The harms that would make it to court, and again, we haven't really seen this because people aren't that litigious. But it could happen is that if there are some pollutants or contaminants in the water gets into the soil, could cause contamination of groundwater or wells. And I think states across the country don't put trespass in the right to farm laws because if that happens, again, it's not like you just get free money. It's not like, it's not in the right to farm law, so I'm going to go to court and I'm going to get me some money. You still have to show physical invasion, harm, and that, it justifies the cost of going to court. Right to farm laws are just basically saying, we're going to add another part of the standard in this case. Well, if the farmer was engaged in good practices, you'd also have to show that as well. And, we're just saying that's not appropriate with trespass. It is appropriate with nuisance when it's just typical sort of odor and noise and dust issues that are being that are part of just regular farming. And that is something we want to discourage. But with trespass, let the legal system play out. Again, still hard. You have to have the harm. You have to have it to be so severe that it was worth going to court over. And the burden of proof is still on the plaintiff. It's on the property owner who's alleging harm. The burden is not on the farmer. These are very difficult cases to win. And as Scott Sanderson said, it's really kind of funny, having studied these right to farm laws over the last few years, it is a balance because if you get to court, when you add things to the right to farm law, it's making the litigation more costly. It's making it more complicated because you're adding layers of standards and reviews. All that will get litigated. The standing issue, the takings issue get litigated. What does good standing mean? That'll get litigated. All for putting that burden on the plaintiff to show that a farmer is not in good standing, but that's another thing to argue about, right? It's another thing to have expert witnesses on. And I don't think that's good for the farmers. And I think that the bill that came out of the House Judiciary, I think complicates things, and I'll go through it and make that, I'll try to make that case.
Let's do that.
Yeah, I just had a question,
Yeah,
can
go
I
ahead.
follow up here? Is negligence and gross negligence also part of that?
So again, I'm sorry.
Litigation, because, you know, if like in PFAS or farmers, they might say, I didn't know this was happening, you know, that I followed all the rules, but some physical harm happened to my neighbor. And, you know, there must be a continuum there where it's actually like, oh, you know, starting with I wanted to do this, there was intent, versus I was just sloppy, versus I didn't even know, you know, that this was happening until it was brought to my attention.
Yeah, so all negligence is also part of all those suits, but you can win on any one of them. Trespass and nuisance don't involve that this negligence standard that you just cited well, which is you know, I was doing what I was supposed to do. I was just following the regulations, or there was no regulations. What Right to Farm does in effect with nuisance is bring a negligence standard into it, which we think is appropriate. It's basically saying, well, it's not just you know, your property is near a farm and you feel what's happening on the farm interfering with your use and enjoyment of the property. With Right to Farm, we're saying, well, you have to show there was sort of a negligence, that the farmer wasn't in good standing. It's not enough, because we're saying to those property owners that you don't really understand what's involved with farming, and you don't really understand that this is normal. And we're an agricultural state, and you need to respect that and expect that, essentially. And we're just saying, don't extend that to trespass, because that is a different set of concerns. And again, I do think it's important to note, it would make Vermont a real outlier in this. And I just don't think that's where Vermont wants to go with that. So one last thing I'd like to say before I go through the bill is, so you're gonna hear S-124, you heard a little testimony yesterday, and I know you're having testimony today, all through the week. And this is another issue with trespass, and it gets to your point about the RAPs. And with regard to the water quality issues, we've been in a struggle. When I say we, well, I guess it's the royal we, but it's also, you know, CLF filed this petition with EPA that you heard about. VNRC was part of that petition, along with Lake Champlain Committee. And the petition was based on, and you're going to hear this as you go through S-124, record reviews that we did that showed ANR and the Agency of Ag disagreeing about when there was compliance with the RAPs and water law. And we have evidence, not conjecture, not opinion, but we had evidence based on the records that we made that showed ANR saying, this is a violation of the water laws for farming. And the Agency of Ag saying, we don't agree. The agencies fighting with each other and the situation not being addressed. And our petition to EPA said, basically, that's not tenable. Like, we need a system of regulation for water in Vermont, even if you're right that the water regulations have been much improved, and I agree with that. It's the implementation of the regulations. And EPA objectively looked at the petition and said, you know, they've been looking at this petition for 2 years now. And I think within the first year, they were like, okay, this is a problem here. It's a problem when you have two agencies involved with implementing these regulations. One agency saying there's a violation that needs to be addressed, there's a problem that needs to be addressed. Another agency saying there's not, and then the problem's not getting addressed. So EPA basically said, this is their role as an overseer of, you know, clean water laws all across the country. You got to fix this. So what S-124 is about, and what you're going to hear, is that how do we fix that, right? And the reason it's relevant to this, and I'm bringing it up, is that if you squarely bring kind of water discharges into this through trespass, it's bringing it in the context of a regulatory implementation of a regulatory system that we believe clearly isn't working. You know, it's not just you know, VNRC and CLF and Lake Champlain Committee, it's EPA agreeing it's not working. Now, we haven't agreed on what the fix to that is, and that's S-124. But the point is that makes this even more complicated in this bill. If you're saying good practices, and I think with regard to odors and noise and dust and all the other practices that farmers are engaged in that are squarely nuisances, I have confidence that we know what it means to be in good standing. And I think it's fair to bring in that negligence component to, nuisance issues with the right to farm law. But I don't think it's appropriate to bring it in with these water issues when we don't have clarity right now about what it means in compliance. Because I don't know, I think it'd be very difficult. It's going to be a judge trying to figure that out. Anyway, so I just wanted to make that linkage. And I think it's super interesting that you have both of these bills now at the same time.
One more quick question.
And I'll go through.
Just quickly, since you teach environmental law, I just wondered about other communities with like let's call it right to recreate. So if I'm a neighbor and there's a shooting range next door, or I'm a neighbor and there's a, ATV park, sand pit next door with a lot of dust, and I'm in Tunbridge and there are no ordinances, so municipal zoning doesn't come into it. These cases come up a lot too. I mean, because as a neighbor, I could say my right to enjoy my property is less now because there's shooting all day long, or there's dust blowing from ATVs using the sand pit. I just wondered how it, compares as far as it's like, farmers have a right to farm, but recreators, do they also bring it, or defend themselves saying we have a right to recreate as long as we're not breaking any laws?
Well, you're right. I mean, so certainly issues come up in communities, as you well know, but it does, again, Vermonters are not litigious, so it doesn't really there are not, I can't think of any examples of real lawsuits around it because they usually get resolved. Usually the select board comes in, even if you don't have zoning, and they'll say, hey, look, can you just cut it out after 8 o'clock or set whatever it is, or maybe not on Sunday when people are trying to have some peace and quiet, and or you have zoning that it's a zoning issue that could resolve it. We did have a situation in Marshfield years back where there was a shooting range and they said that they didn't need a zoning permit. And neighbors complained and they got pulled into zoning and the issues got resolved. But they don't really, people mostly work it out. Isn't a lot of litigation, but there could be. But those are nuisance issues. Those are classic nuisance issues. It's noise, right? But again, you have to have, it's expensive to litigate. It really is. People don't want to litigate. They don't have the money to litigate, and you're only going to do it if you haven't been able to work it out otherwise, and you think you're going to prevail to get what you want. And what most people want is to be made whole. They're not looking for the big payday in Vermont. I can't say that about other parts of the country. That's why you have personal injury commercials, and you see billboards as we drive throughout New England with everyone advertising, come to me when you want to sue somebody. We just don't have that culture in Vermont. It's one of the things I love about living in Vermont. But I think it's pretty obvious if someone came with a right to have a shooting range bill and not be sued, or make it harder to sue, that bill wouldn't get very far in the state of Vermont.
Yeah, so it sounds like overall you're supportive of the right to farm, but removing this trespass piece. So I have a question that feels like maybe it crosses those two boundaries a little bit. We had a scenario where a woman came here last week and testified, and she has a small farm where she raises organic beef. And she has a pond on her property, and she has a neighbor, I think it was a dairy farm, and he raises his cows, but also grows corn for them and does use pesticides. And she found out that the pond on her property, which is adjacent to the dairy farm, is so polluted with pesticides that literally her animals can't even drink from it. But she's been organic for 12 years or something like that. So if they're using their pesticides in the way that's appropriate on their side of the border, or on their side of the property line, but it's getting into the water on the neighbor's side, how does that go? Because it's not exactly like a direct over the top water carrying, but it appears it probably came from the neighbor. So where does that fall? It's not a nuisance because it is going into their property, but Yeah, how does
Well,
that, how
I mean,
does
that's a
that
great-
play?
So that, I think, so this gets to how hard these suits are to win. So you'd have to prove it. So it would be the burden, forget about the right to farm law, just put this to the side.
Yeah.
Under just normal law,
Yeah,
the burden is on that landowner to prove that the contamination came from the farm and is causing harm. And then to quantify what that harm was and what the remedy is, meaning stop the activity, fix what you've hurt. And the burden is to hire experts and to try to figure it out, do an investigation. And that's expensive and difficult to do. If you could prove that there was the conveyance of, it's kind of like the toxic pollution case I mentioned in San Gobain in Bennington, there were releases directly running off from the property, but there was also the smokestack and pollutants through the smokestack being deposited on properties, near the plant. And the lawyers raised nuisance and trespass and negligence, and that's what you always get. But you have to prove it. You have the burden to prove it. And unless there's an investigation, you don't really know, which is why these cases are so hard, which is why I'm cautioning about, like, this is a real privilege to the point about we don't have right to X, Y, and Z laws that, again, don't prevent lawsuits. It just means if there is a lawsuit, you're adding other standards. So it's not just how difficult it is in this example to say, okay, what's happening here? Burden is on the plaintiff to show that my neighbor actually discharged and caused harm. And then you could go to court with that evidence and people get cross-examined, and you have to go through a rigorous process to determine what's true. And then a judge or jury ultimately makes a decision. That's hard enough. This would just be layering on top of that, like another standard to make it even harder. So I would say the system's already hard in those situations. That property owner has some tough choices to make, but the way property law works in this country and in England, where we took this common law, is that we're basically going to make it hard for you to interfere with what people want to do in their property. You're going to really have to have evidence that someone has acted in a way that's caused harm to you and that you should be able to recover in court. So we're saying just don't layer that into this statute. Keep it with the classic nuisance issues. That, as I think what the intent of the right to farm law has been in Vermont and all over the country, is to make sure, like, especially if you come to an area and you're not used to the smells and the activities, that you don't take that as like something out of the ordinary and something that you would want to sue over if that was your inclination.
So in the bill as it stands with the right to farm part, I mean, my understanding is that part of it is, if you have a farm and you're using it for one kind of farming and then you're going to change to another one, that should be okay.
Well, that was taken out of the bill, and I support that. So maybe it's a good segue into, I don't have that many, so it'll.
Representative Nelson had one very quick question.
On that issue, I've got them hooked up with the Agency of Agriculture and the pesticide division, and they're looking into that.
Yeah,
Because my license,
Yeah.
I'm licensed,
Yeah.
my license says my herbicides, my pesticides stay on my property.
Yeah.
No exceptions, no excuses.
Yeah.
And so I've helped get them hooked up, and the REPs
Yeah.
and all that says everything stays on my property. The great thing about this bill, this act, gives us the same protection as a shoplifter. We're presumed innocent until proven guilty. There's still the right to go to court, there's still the right for arbitration, mediation, but the rebuttable presumption,
Goes away in this bill, and we support that.
you support that?
Yeah.
That's
So
good.
let's
Yeah.
because we're down to 12 minutes,
Yeah.
and I want to be sure that we give you enough time to go through the pieces of the bill, specific sections of the bill that you have.
Yeah, they're not that many. So on page 4, and this is, like I said, this is the draft 2.1 that Mike O'Grady did. It came from the Judiciary Committee.
Draft 2.1, and that's I think we can all find it. I don't know that it's on our page today, but
Yeah.
That's the one they brought the hard
It's
copy
in
of the
it,
other
yeah,
day.
it's in the back, yeah, page 4.
So on the top of page 4, number 4, this is what I was referring to where they define nuisance. And I think that this creates more, this is my less is more pitch to you all, is that I know what they were trying to do, but you don't, and this is where I agree with Steve Collier. And we don't agree a lot these days. But the common law defines nuisance. The courts know what nuisance is. It's been around before this country was founded. And by saying what nuisance is, you might leave something out. You're basically directing the court to look at all of these things, with regard, to things like particulate matter. Then it'll have debates about, well, what does that mean? Then because they're defining nuisance, then what the committee did was like, well, we want to make sure that nuisance doesn't include water issues because they were concerned about some of the things that I talked about earlier. And then they said, well, then we need to have definitions of, well, what's not what's a flood event? What's an extraordinary? And I'm not saying Mike O'Grady, I think, picked 2 choices for that, which are reasonable. But again, it'll cause debate and about, well, is a water event fall into one of these categories or not? And I'm just saying less is more. Don't define nuisance, and you don't need alternative 1. You don't need alternative 2. I hadn't heard that the existing right to farm law. I heard about the presumption being a concern. All for getting rid of that and putting the burden on the plaintiff to show that a farmer's not in good standing. But I wouldn't define nuisance. I just think it causes problems, and it leads to continue to define things and add things to the law that I think will cause problems.
in that nuisance definition, lines 3 through 6, so before you get to the water alternatives, what does it mean? What would it imply to include here nuisance, negligence, trespass as it does?
Yeah, so this is another thing. This is really problematic because I'm not sure what the intent is with this, but in a way, it kind of what this is saying to me, and there's another line in here. This is a line. It basically says, even if you sue in trespass, but if a court says it's really a nuisance, then they're going to consider it a nuisance. Again, it's going to create an argument about whether trespass issue is really a nuisance or not. If you file a case and you raise a trespass claim, court is quite capable of determining whether there's a physical invasion and there's harm, and that claim should be, there should be an award of damages in that claim. This is very confusing. I mean, it's basically saying to a court, you need to scrutinize if someone brings a nuisance claim, you need to decide, is that really nuisance? Maybe it's really negligence. Maybe it's trespass. And it's just directing the court and the parties to fight about that and to litigate it. And I'm not aware of anything like this in any other statute in the country, which is why less is more. It's been working. I haven't heard that the common law has not been working. What I've heard is that the presumption is not working. The definition of what it means to be in good standing has not been clear. We're fixing those things in that bill, and we support that. But that's a great, thank you for directing that, Mr. Chair. That's a really confusing sentence and would not be necessary if we don't try to define what's already in the common law, essentially. The next point I want to make is actually just for clarification on page 5, and line 6. And I'm going to tie this to something that you talked about last week on page 6, line 14. And I want to point out that, so this is this strikeout, this page 5, lines 1 through 11 is basically getting rid of the presumption, which we support.
Existing law.
Yeah, the existing language. And part of that existing language was this issue of, in determining about whether the presumption of compliance with good practices existed, and therefore the right to farm law protections applied to a farmer, was this criteria is that activities on the farm had not significantly changed since the commencement of the prior activity. And we're getting rid of that, which I think is good, because I think that created confusion. And this was of the two right to farm cases that I'm aware of, one was this Trickett's v. Oaks case. It was an apple orchard, I think in Addison County, where, one of the issues was, did the orchard change its practices? It was still engaging in, and it was still an apple orchard, but it changed some of the ways it did it. And the court basically said, well, that was enough to basically trigger that. And I think that was, seemed to me maybe the wrong decision to me, but I'm glad that they're getting rid of that. But the reason I bring that up is if you now look on page 6, line 14, this is the new language. It's all part of the new language about whether a plaintiff can prove that an activity is a nuisance on a farm. And then on line 14, it says the agricultural activity has a substantial adverse effect on public health and safety. I just wanted to point out that where that came from, in the House Judiciary, they had this whole discussion about, okay, we're getting rid of the standard that I just discussed about a change at a farm. And there was a whole conversation about, like, not the apple orchard case, Trickett v. Oaks, but like, well, what if a farm goes from being a vegetable farm to a hog farm, like something extreme? Like, that would seem, maybe should that kick you out of these right to farm protections? And what the committee got to is that they added that line. Well, maybe if we give people a chance to say, whatever is happening on the farm, that there's having a substantial adverse effect on public health and safety, that was a way to get at an issue without micro focusing on the change at the farm, but trying to create some safety valve for people to argue that whatever the activities are was having this substantial effect. So I'm not married. I just wanted to point out that was how that got linked in there. And as you review the bill and think about that, I think if you don't go with that standard, I think that's still a concern that I think that you want to make sure that, and maybe it's covered by whether a farm is in good standing or not, but that's something that the House Judiciary Committee really wrestled with.
So it's interesting, John. I think the administration or the agency took issue with the word public in that language on line 14, that it suddenly become a private matter between, two neighbors in a civil case, and now making it somehow a public health issue. And I don't know whether this has come up before, but I immediately went back to the existing statute. So the rebuttable piece here, the part that you make the case in rebutting, is specifically dealing with health and safety. So that's being struck, right, from the existing law. And I took this new language to somehow be replacing what's in the section 2. So I'm on page 5.
I think that's right. So I think they're getting rid of focusing on the activity on the farm, but putting this as like a backstop, basically. And I'm not sure that it works, but I was sympathetic to what they were trying to do. And that's sympathetic to trying to get away from, again, microanalyzing like the activity on the farm, and it changed either in degree, like the Trickett v. Oaks, or entirely like the vegetable farm to a hog farm, and say, well, really the issue is whether or not, if someone can prove there's a substantial adverse effect. And I don't disagree that the word public really isn't about the public. It's really about the neighboring property owner. But that's what they were trying to get at. You're right, in replacing so we have no more presumption, but we do have this kind of safety valve, right? And the burden is on the plaintiff to prove all of those things.
Representative Nelson.
So on page 7, line 7, to this point, this chapter shall not restrict or impede the authority of the state to protect the public health, safety, environment, and welfare. So I think most farmers, I probably shouldn't speak for all farmers, but I'm going to. We trust that the state will enact in faith for the public. And on, the previous line you mentioned, line 14, that concerned me because not a changing from a vegetable farm to a hog farm, but my neighbor changing and they're allergic to hay. And, you know, we try to cut our hay before it goes to head because it's better for the cattle, more nutritious, but if you have weather events, you can't get on there and your Timothy goes to blow, you know, pollinating, and that neighbor has asthma and hay allergies. And so, you know, I realize what I'm doing is normal, but because my neighbor has changed, now maybe I have adverse effect on their health. And so that's, but it's not so much on the public health, it's their health. And that's the problem I had with this line, whereas this other line on page 7, line 7,
Yep.
it is more amendable to me.
Yeah.
And I hadn't thought, and I was thinking not so much a vegetable farm to a hog farm, but I was thinking a dairy farm that changes use and someone goes in and builds a beautiful vegetable farm and they want to have a farm stand there and they're getting traffic and the neighbors aren't used to traffic all the time.
Right.
And this is a case going on in New Hampshire with Vernon Family Farm down in Newfields, New Hampshire, and they've been dragged through the mud for 3 years over this.
Yeah, no, that's a good example. And I agree with you. That's why I'm all for getting rid of that standard. I just wanted to point out how, you know, your chair is completely right. Basically substituting all that strike through with this, that last catch-all line was a way to try to get away from the issues you're talking about. The other line that you're mentioning, really, I'm not sure it's really needed, but I certainly have no problem with it. It basically wants to make it clear that whatever the issues are between neighbors has nothing to do with the state's authority to deal with regulatory issues.
Yeah.
I think that's obvious. So I don't think it's harmful to say it, but I don't know that it's necessary to say it either. If you took it out, I wouldn't. I think that's the law. I don't think that it does interfere. But that was the intent. I think there was being out of an abundance of caution, right? We want to make it clear that nothing in this statute is intended to affect, you know, the issues of just the state's authority to implement all of its the statutes that it has.
Representative Bryan.
John, what happens in the case of where a plaintiff could sue both farmer neighbor, but also the state, and I'm sort of starting from PFAS, but also thinking of, like, let's say neonics that Richard's planting with treated artificial seeds, and I could say that's harming not only the bees I raise, but wild pollinators and benthic macroinvertebrates in my stream, and the state of Vermont saying Richard's doing nothing wrong, he's following the rules. But I could certainly bring a suit, right, against both the farmer and the state of Vermont.
No, and you really couldn't sue the state. It would really be the farmer, and it would be hard because it's meaningful. No matter what you write in these laws, this is your point about negligence. It would be very powerful. This is what happens in the toxic cases. This is what happened in Bennington. Like Saint-Gobain said, and they weren't wrong. They were like, EPA didn't have any regulations about PFAS, and they didn't. They didn't regulate air pollution with PFAS in it. They didn't regulate the storage and disposal of PFAS. So we weren't negligent. Like, we were following all the rules. And the same could be said with your example. And it would be very hard for you to win that case, which is why I think it's important. You know, we have these really hard debates about what are the pesticide rules in the state and the neonic bill that passed, like trying to basically say, what is the evidence of like harm? What are the practices? Because what the government requires really has a major effect on the ability of people to even access the courts and to win. And again, because it's so expensive, you're not going to do it. You go to a lawyer and with your fact scenario, lawyers say, I think it's nearly impossible to win that case because it's allowed.
You can bring a nuisance claim against a state, or
no, you really can't sue. You can't. No, you.
So that's not, common
No.
law doesn't apply to,
It's hard to sue the state. The state has something that's called sovereign immunity too. It's even doubly hard to sue the state. You basically sue the state when they have a law that is, well, you could challenge the law. You could basically say that the law is arbitrary and it's not. I mean, we've had a debate about like the new pesticide regulations, like that's where that kind of came in. Are the regulations consistent with state law? It's the state law though. If the state says these pesticides you could use, if you use them and if you use them in this way, we're ordaining that and saying that is legal. You really can't, you really can't sue. You could try to sue. This is really why and this is not about the farmer, like it goes to the manufacturers of these things, right? So with PFAS, that's where the litigation has gone. It's Monsanto, it's 3M. And I think with pesticides, it's similar, right? You've seen the big judgments are against the manufacturers because they go to governments and they say, they make all these representations about how safe all these things are. And that's who's causing the harm, right? You're going to go up the ladder because the governments are just like at their mercy as much as anybody, you know? So it's Monsanto in that case, right?
Okay.
So, but no, it's why the laws you pass in this regard are so important, you know?
so, we need to wrap it up. John, thank you for coming
And
in.
the very last thing is on page 6 on line 16, which is something that's near and dear to my heart, where the committee said, oh, you can't, nuisance doesn't include water pollution. But I think if you don't define nuisance, you don't need that. Like they put that in there because they were defining nuisance. And again, I think it just like creates confusion. It's like, so now we're defining nuisance, we're saying it's this, it's not that. Oh, now we have to have another line in there that says, well, it's definitely not that. You're just directing the court and all the parties to argue about that. So you could get rid of that too if you don't
We don't have.
do the definition of nuisance, right? So thank you for the time.
Just line 16, but it's,
Yeah,
Section D.
right. What comes after that? Okay.
yeah, just onto page 7. Yeah.
I'm gonna eat my lodgings now, so thank you.
Well, you did a lot of talking over the last,
I did, I know.
maybe another lozenge would be in order if you need
Yeah.
it.
I appreciate the time and these are tricky issues, so.
All right, thank you. We'll take a break until 10:30. We've got